Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. We are going to discuss about a very important judgment, a landmark judgment. But it is our regular practice that before dealing with the subject or before dealing with the topic, it is our regular practice that we recite preamble of the Constitution of India. It is reminding oneself that we need to achieve those goals enshrined in the preamble. And being the lawyer in the apex court, you should know the values of the preamble, and you are the creamy layer of the lawyers community is. So we have to set a role model and we have to follow the goals, what is enshrined in the preamble, and we should recite every day as a daily prayer. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. I welcome each one of you to our 62nd lecture, where we are going to discuss about this important case, that is Mineral Area Development Authority and another versus Steel Authority of India. In this case, as I said earlier, we will be seeing the backgrounds of the case, issues involved, then conclusion, reasons to the conclusion, and then summary of the judgment. Dear friends, let me ask your attention to page number 54 of the SCC judgment. Please note down, I am referring to 2024 volume 10 SCC page 1. So page 54 is the background of the case. Page 54 is the background of the case. Let me read, dear friends. The present batch of appeals bears on the distribution of legislative powers between the union and the states on the taxation of mineral rights. So this is with respect to the distribution of legislative powers between the union and the states on the taxation of mineral rights. The legislative entry which lies at the core of the present reference is, dear friends, you have to note down two important provisions, that is list 2, entry 50 of schedule 7 to the Constitution. Let me repeat, list 2, entry 50 of schedule 7 to the Constitution. List 2 means it talks about states' power. The entry deals with taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. This is what list 2 entry 50 is. That is, this entry deals with taxes on mineral rights. So states' power to levy tax on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. Regulation of mines and mineral development is enumerated Under both the union list, this also I request you to note down, dear friends. Under union list, list 1 entry 54, list 1 entry 54. So these are the important provisions. Number 2, Parliament enacted the Mines and Minerals Development and Regulation Act 1957 in exercise of its legislative power under Article 246 of the Constitution. What does it say, Article 246? It talks about that powers, it talks about the 7th schedule. Under 7th schedule, there are 3 lists: union list, state list, and concurrent list. Under union list, whatever the entries or subject matters are referred there, Parliament has the power to enact law on those entries, on those subject matters. This is what union list is. List 2, that is concurrent list, state list, which empowers the state to enact a law. Concurrent list, where this both union parliament as well as the state legislature has power to enact a law on those subject matters which falls under the concurrent list. But if both the law, that is Central Act and the State Act, 2 acts are prevailing on the same subject matter in the concurrent list, if they are repugnant to each other, some of the provisions are repugnant to each other, contradictory to each other, then Central Act will prevail over the State Act. This is what the scheme of 7th schedule is. So the origin, the source of power for the Parliament to enact a law, or the source of power vested with the state legislature, that you will find in the 7th schedule, list 1, list 2 and list 3, dear friends. So the Parliament enacted the Mines and Minerals Development and Regulation Act 1957 in exercise of its legislative power under Article 246 of the Constitution. The subject which the legislation predominantly covers is relatable to list 1 entry 54. MMDR Act, that is Mines and Minerals Development and Regulation Act, is a comprehensive code for the regulation of mines and development of minerals. Section 9, this is also very important provision. Section 9 of MMDR Act provides that the holder of a mining lease shall pay royalty in respect of any mineral removed or consumed from the leased area at the specified rates. So they have introduced about Article 246 and 3 lists are introduced. In the second para, they have introduced MMDR Act. In third para, they are going to discuss about what are the divergent views between 2 constitution bench judgment. In India's Cement Limited, because 9 judges bench deciding the correctness of this judgment only, India's Cement Limited versus State of Tamil Nadu. It is reported in 1990, Volume 1, Supreme Court Cases, page number 12. A 7-judge bench of this court held that royalty is a tax and the state legislatures lack competence to levy taxes on mineral rights because the subject matter is covered by MMDR Act. So what they are saying is, state cannot impose tax. It is a power vested with the Parliament by virtue of this MMDR Act. That alone can levy tax, not the state government. The court also held that royalty cannot be used by the state legislature as a measure of tax on mineral bearing lands under list 2 entry 49. You note down this list 2 entry 49 also. So this is what India Cement Limited has held. Later in time, there is yet another case, dear friends. State of West Bengal versus Kesoram Industries Limited. That is reported in 2004 volume 10 SEC page number 201. I repeat, 2004 volume 10 SEC page 201. According to this judgment, Kesoram Industries Limited comprising of 5 judges. India Cement 7 judges, Kesoram is combination of 5 learned judges. A constitution bench of this court held that the decision in India Cement stemmed from an inadvertent error and clarified that royalty is not a tax. So 7 judges have held that royalty is a tax, but Kesoram has said, clarified that royalty is not a tax. So it creates confusion in the minds of the litigants also, as well as in the minds of the Honorable High Court also. So it required an authoritative pronouncement again by the Supreme Court. So in the aftermath, so after this decision is over, what is the consequence of this Kesoram? The consequence now follows. In the aftermath of India Cement and Kesoram, state legislatures exercise their legislative power to impose taxes on mineral bearing land in pursuance of list 2 entry 49 by applying the mineral value or royalty as a measure of the tax. States such as Rajasthan and Uttar Pradesh also sought to impose environment and health cess and fees for transporting coal and coal dust collected from mines. The constitutional validity of these levies. So after Kesoram, they have held that state has the power to levy tax. State has the legislative competence. So immediately, state legislatures like the state of UP, Rajasthan, they have started enacting a law to impose a tax. So that was challenged. This is what they are saying. The constitutional validity of these levies was challenged before the high courts on the ground that they were beyond the legislative competence of the state legislatures. That is the challenge. Number 2 challenge was the levies were also assailed on the ground that they were in violation of the law laid down in India Cement. Because India Cement, what they have said? Royalty is a tax. So now state legislature is enacting a law, thereby imposing a tax. This is against the landmark judgment, constitution bench judgment, which was held in India Cement case. So that was a challenge before the High Court. One such matter in civil appeal number so and so, where the petitioners initially filed writ petitions before the High Court of Judicature at Patna, challenging the validity of the Bihar Coal Mining Area Development Authority Amendment Act. Bihar also, they have made certain amendments that was challenged, and the Bihar Mineral Area Development Authority Land Use Tax Rules 1994, which levied tax on land being used for mining. Relying on India Cement, the High Court allowed it. So the challenge was allowed, meaning thereby state of Bihar has no legislative competence to levy a tax by relying upon India Cement's case. High Court allowed the petition by holding that the tax was not within the scope of List 2, Entry 49 of Schedule 7. The correctness of High Court's decision was assailed before this court. That was challenged before the Supreme Court. On 30th March 2011, a bench of 3 judges noticed the divergence between, divergence, a difference of opinion between India Cement and Kesoram, and referred the following questions to bench of 9 judges to provide a decisive ruling for authoritative pronouncement that they have referred. Is it clear, dear friends? What is how the matter has travelled? Ultimately, after Kesoram, they have said state has the power to impose tax. Once the Supreme Court has held in Kesoram, immediately state of Rajasthan, state of UP, state of Bihar started imposing tax. That was challenged before the concerned high courts on the ground that it violates India Cement's case. Number two, it has no legislative competence at all, because the competence rests with the parliament, not with the state. That was a challenge. India Cements, 7 judges bench. So it has a binding effect on the high courts. So the high courts relied upon 7 judges bench judgment and held that state has no power to levy a tax. So matter came up before 3 judges bench. 3 judges bench of the Honorable Supreme Court have found Kesoram has taken a different view from India Cements case. So which is the correct law? When 2 judgments are there, 5 judges and 7 judges, so it went to the 9 judges bench. This is how the matter traveled to the 9 judges bench. Now, background of the case is over. Issues for consideration is, second heading is, issues for consideration is whether the views expressed in India Cements Limited is correct or incorrect. Whether does it require revisiting the judgment in India Cements, whether it is to be sustained or overruled or clarified. So there were many issues before the Honorable Supreme Court. That was before the larger bench. I am not reading the issues, dear friends. Let us go directly to the conclusion. What the Honorable Judges has held in majority view, and then I will take you to the reasons for that conclusion. As I have already said, the third heading, the decision of the Supreme Court is 8:1. Majority 8 judges has overruled India Cements Limited case, and one minority judgment by Ladyship Honorable Justice B.V. Nagaratna. Her Ladyship has given sole dissenting judgment. That will be dealt in a separate session. So, decision of the Supreme Court is over. Now, let us come to the conclusions. Very, very important. In the conclusion, the majority of 8 judges authored by the Chief Justice, the then Chief Justice of India, Dr. D.Y. Chandrachud, His Lordship has summarized in 9 points. In 9 points they have summarized, but each point, the background is almost running to 50 pages, 60 pages to arrive at one point. That one conclusion has a historical background of 50, 60 pages. So therefore, dear friends, for AOR aspirants, those who are going to write exam, these conclusions are very, very important. You are expected to write this conclusion only. So make it simple and don't forget to write in your own way. Understand the essence. You are not asked to repeat what they have said. They want to test your application of mind, not memory power. Application, how are you going to apply? So understand the case and put it in your own words. Therefore, you will not forget it. So let us go to the first conclusion, dear friends. In view of the above discussion, we answer the questions formulated in the reference in terms of the following conclusions. Number 1, this paragraph is 365.1. So, royalty is not a tax. I repeat, royalty is not a tax. Then what is it? What is royalty means? They are explaining. Royalty is a contractual consideration paid by the mining lessee to the lessor for enjoyment of mineral rights. So, royalty is nothing but a contractual consideration paid by the lessee to the leaseholder. The liability to pay royalty arises out of the contractual conditions of the mining lease. So, it is arising out of the contractual conditions of the mining lease. The payments made to the government the payments made to the government cannot be deemed to be a tax. So royalty cannot be deemed to be a tax merely because the statute provides for their recovery as arrears. When the assessee, if they fail to make payment of tax, how the recovery will take place, recovery of arrears of tax. The same procedure is followed by the state in terms of royalty also. But if the same procedure is followed, it doesn't mean that royalty will become a tax. Royalty is completely different. Tax is completely different. Why? Royalty takes birth from the agreement. It flows from the agreement. And it is a contractual relationship between the leaseholder and the lessee. Whereas tax is not so. If it is breached, the contract is breached, the state can initiate action as if it is arrears of tax. So if you are simply following that procedure, it doesn't mean that royalty will become a tax. So this is what the conclusion, dear friends. To arrive at this conclusion, what was discussed by the honorable judges, that is very important. Reasons. Page number 102. Page number 102, para 130. Page number 102, para 130, dear friends. Royalty is not a tax. On first principles, see how beautifully they are interpreting. On first principles, royalty is a consideration paid by a mining lessee to the lessor for enjoyment of mineral rights and to compensate for the loss of value of minerals suffered by the owner of the minerals. The marginal note to section 9 of MMDR Act, Mines and Minerals Regulation Act, states that royalties are in respect of mining leases. The liability to pay royalty arises out of the contractual conditions of the mining lease. A failure of the lessee to pay royalty is considered to be a breach of the terms of the contract, allowing the lessor to determine the lease and initiate proceedings for recovery against the lessee. So this is what the royalty is. In simple terms, what we can understand is royalty is a consideration received by the leaseholder from the lessee by virtue of the lease agreement. That's all. Now, what are the major conceptual differences between royalty and tax? So they are taking us to, now they have explained what is royalty is. Now they are asking us, what are the differences between royalty and a tax? Tell us. So that is being discussed in para 133, dear friends. There are major conceptual differences between royalty and a tax. Number one, there are 3 points discussed. Number one, the proprietor charges royalty as a consideration for parting with the right to win minerals, while a tax is an imposition of a sovereign. So it's a sovereign exercise of the state in levying a tax. It's a sovereign exercise of the power. But whereas royalty is only a contractual condition. Number two, royalty is paid in consideration of doing a particular action, that is extracting minerals from the soil, whereas while tax is generally levied with respect to a taxable event determined by law. It is an event determined by law. Number three, royalty generally flows from the lease deed as compared to tax, which is imposed by authority of law. So tax is not imposed by any agreement. It is by virtue of authority of law, whereas royalty generally flows from the lease deed. So these are the differences between royalty and the tax, dear friends. Now moving on to the second conclusion. There are 9 points I said. Paragraph 365.2. See, these are all important provisions. You should never forget. List 2, entry 50. I repeat. List 2, entry 50 does not constitute an exception to the position of law laid down in M.P.V.SARAVANARAJA. There is a case, a judgment, M.P.V.SARAVANARAJA. So they are asking the question, list 2, entry 50. This is a conclusion actually. List 2, entry 50 does not constitute an exception to the position of the law laid down in M.P.V.SARAVANARAJA. I will explain you what is the principles in Sundararamayya. The legislative power to tax mineral rights vests with the state legislatures. See, the authoritative pronouncement of the Honorable Supreme Court is the legislative power to tax mineral rights vests with the state legislatures. Parliament does not have, see, very important, dear friends, look at the authoritative pronouncement of law for our country. Parliament does not have legislative competence to tax mineral rights under list 1, entry 54. Why? Reason is, it being a general entry. That means list 1, entry 54, empowering the parliament to make a regulation with respect to the mineral rights, it is only falling under the general entry. But list 2, entry 50 is a special entry, a specific entry. Therefore, general diary or general entry, we cannot supersede or cannot intrude into the state power. Since the power to tax mineral rights is enumerated in list 2, entry 50, Parliament cannot use its residuary powers with respect to the subject matter. So this is the conclusion in point number 2, dear friends. I read one more point also and then give you the reasons. List 2, entry 50 envisages that Parliament can impose any limitations on the legislative field created by that entry under a law relating to mineral development. The MMDR Act as it stands has not imposed any limitations as envisaged in list 2, entry 50. What they are saying is, with respect to list 2, entry 50 is concerned, that Parliament can impose certain limitations by enactment of a law. So what is that law? The law is Mines and Minerals and Development Regulation Act. That by enacting that law, they have not prohibited or limited the state's power from levying the tax. So based on these two conclusions, dear friends, what are the reasons to this? That is page number 128. List 2, entry 50 does not constitute an exception to the Sundararamayya principle. So they have said it is not an exception to Sundararamayya principle. So what is the principle? So the position which was enunciated in M.P.V.SARAVANARAJA and accepted in Jindal Stainless is that the field of taxation is distinct from the general subjects of legislation in the union and state list of the 7th schedule. Dear friends, what they are going to discuss here is state's power versus parliament power. State power under list 2, entry 50, whereas parliament's power under list 1, entry 54. This is what they are going to see, whether state has the power or the parliament has the power. So how they are going to beautifully interpret, let us see. The issue which needs to be addressed is whether list 2 entry 50 is an exception to the position which has been laid down in M.P.V.SARAVANARAJA. In view of the fact that the ambit of a taxing entry is sought to be restricted by a regulatory entry, a related issue is whether Parliament has the legislative competence to tax mineral rights under its residuary powers. So there is a specific provision, that is list 2 entry 50, which empowers the state to impose a tax on mineral rights. That is specific entry. But whether that can be overridden by the parliament by virtue of the general entry, that is list 1 entry 54. What does it say, Sundara Ramaiah? Let us see. The court referred to M.P.V.SARAVANARAJA to reiterate that. Now they are narrating these principles involved in Sundara Ramaiah case. Number 1, there are 4 points, dear friends. Number 1, taxation is considered to be a distinct matter for purposes of legislative competence. Dear friends, one thing I need to tell you, generally when we discuss about the bail matters, I'm just deviating from here. Bail is a rule, jail is an exception. This we all know in criminal jurisprudence. But as far as certain criminal matters are concerned, like PMLA, UAPA, POXO, economic matters, the law of bail is not as wide and as broadened as that of earlier, not normal bail. In economic matters, the approach is different. You cannot say bail means bail. You cannot apply to the economic matters. You cannot apply to the same principle to PMLA matters, that is prevention of money laundering. So therefore, everything has to be touched, discussed, deliberated with reference to the context. That is very important. Context is very important. So likewise, when we are talking about taxation law, there should be a specific provision empowering the state or empowering the parliament to enact a law to impose a tax. You cannot find your source through a residuary power. You need to find it through a specific provision. That is important. So this is what Sundara Ramaiah says. Taxation is considered to be a distinct matter for purposes of legislative competence. So when a state is enacting a law to impose a tax, you should find your competence through a specific provision. Number 2, the power to tax cannot be deduced from a general legislative entry. You cannot find, Parliament cannot find a source from a general entry. That is not possible. 3, the taxing powers of the union and the states are mutually exclusive without any overlap. So the Parliament's power is different, state's power is different, and does not overlap with each other. Number 4, this is also evident from the fact that there is no taxing entry in list 3. So these are all the principles enshrined in M.P.V.Sundara Ramaiah by saying that Sundara Ramaiah principle in simple terms, in our own way, in simple language, what we can say is that with respect to levying a tax, state legislature, when it wants to enact a law, it has to enact a law from a specific provision. That is, list 2 entry 50 is there. But as far as the parliament power is concerned, list 1 entry 54 It is a residuary power, it is not a specific power provides to the parliament. So general entry for the parliament cannot overlap with the state's power, that is list 2 entry 50. So this is what they have held in Sundara Ramaiah case. Therefore, list 2 entry 50 does not constitute an exception to Sundara Ramaiah principle. Both are complementary to each other. So this is what they have held in Sundara Ramaiah case, dear friends. So remaining aspects, I think I can take 5 more minutes, then we will. The second aspect is page number 133b. See how beautifully they have arrived at, lordships have arrived at the conclusions. But those conclusions are based on the reasons and how beautifully they are narrating, explaining with the help of the precedents. So this is A is over. Now page number 133b. What is the nature of any limitation? There is a term in list 2 entry 50 that state has the power to impose tax subject to any limitation imposed by the parliament through authority of law. What is that limitation? Now they are interpreting the limitation. Here, as a law student, we will remain as a law student, though our age may be 80 years or 90 years. Here, lordships have taught us how to split up the sentence and how to understand it. See, beautifully, they have said, para 218, having established that the state legislature has exclusive power to enact law relating to taxes on mineral rights under list 2 entry 50, the next issue is to determine the nature of the limitations that parliament can constitutionally impose on the exercise of the taxing powers of the states. Recap, the latter part of list 2 entry 50 has 3 elements. It is only 3 sentences, it's just few sentences, dear friends, but how they have split up is, number 1, any limitations. Number 2, imposed by parliament by law. And 3, relating to mineral development. If you read the Bare Act, it will say any limitations imposed by parliament by law and relating to mineral development. They have split up. One by one they have done it. So, as held in the above segments, the element of law relating to mineral development can be traced to list 1 entry 54. Parliament has enacted MMDR Act in pursuance of Article 246 read with list 1 entry 54. So they have discussed about what is the limitation. In the next session, what we will be seeing is what is the limitation, to what extent the parliament can impose limitations, and then they have distinguished many aspects also. So that we will be seeing in the next session, dear friends. Before concluding, I request each one of you, whatever we have discussed, please go and read and then come with complete preparation. This is only a lecture which gives you a certain clarification, right? So you make your homework and then come. Thank you so much for your patience hearing. All the best. Yes. Thank you. Thank you. Please join us for a group photo.